I just wanted to go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent.
Drop your volume.
On one issue, in your brief, the most recent one that you filed.
The second one?
Right.
Okay.
On page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath,
right?
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed, and in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order, but I was trying to paint the entire picture and how I felt that it was relevant. And it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right. Now I was just kind of showing why I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that some kind of way this creates a conflict of interest.
No, it's just unethical and it could potentially get a
rule on that, but I still
DQ'd.
think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, yeah. Page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
We can't hear you.
I'm so sorry.
Just pull the microphone, just pull it closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24.
His demeanor's bothering me and his vocal fry is bothering me. Let me just act like I don't care about what's going on here and get the vocal fry. And now let's argue a point that's totally irrelevant.
So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification. Held to arise where the prosecutor had acquired a personal interest.
Yeah, that has nothing to do with the oath.
Conviction.
This guy mixed up oath with conflict.
And I don't, I wish I had that case in front of me. I don't have the case in front of me.
He started by talking about the oath.
Question, that first of all is physical precedent only. So yes, and
but you did cite it.
And said that it's physical precedent only.
And you're using that as the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict.
Guaranteed that that's not true.
And also amusement sales.
So there's already two.
Deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on.
Get in your mic.
I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
They distinguished
Yeah,
that.
the prosecution also. So
Prosecution,
in that case,
exactly.
That's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction.
Not the outcome, it's
And
the
obviously,
prosecution.
The state wants it to be just a conviction. And
They
we
talked
argued
about
this
that
extensively over 3 hours, I think,
Yep.
in front of the court.
Testified.
But it's also a personal stake in
the prosecution, the process.
And that was an amusement, prosecution. In that case, that was a contingency fee case. So
That's
that was
correct.
completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake and just bringing the case.
Yes.
Because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture act.
Correct. But they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the
They
key.
get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
Very
But
smart.
they get money if they win.
Right, but
That's
you-
the only way they get money.
Yes.
They
you
don't get
said
money for
conviction,
bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a
They
conviction.
only get money if they're the victor.
in-
He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
Clip
No,
this. This
you
guy
can
doesn't
lose the
realize
case and
he's
still
making a
have
mistake.
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No,
Prosecuting
the actual
it.
conflict is
Prosecuting the
it's-
case.
That's a long answer. The actual conflict is lying on your disclosures about how much money.
I'm
you
talking
have
as far
to
as
give.
this issue is concerned right here. When you use the Whitworth, you use amusement sales, and they say that there has to be an actual conflict
In bringing
in
the
amusement
suit.
sales. And let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the
Dude,
defense
okay, good,
attorney
you read
came to the
Whitworth.
prosecutor and said, we would like to plead. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict,
answer.
even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taken place?
Yeah, being
It's not just
subjected to
trial, so
one.
It's not limited just to the trial, but to answer the first part of your question, when you were asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleading, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said, no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case,
With a $5,000.
but it was going to end.
It
He was
would.
no more
With the
it was no
conviction.
more billing on that
Interest-
case, because
interest in the
earlier you
conviction.
said- But earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor.
They get a
and
conviction
you
and
rejected it.
17
You're the one who's continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client
Right.
so they can continue to bill.
There were
But he
17 other
basically
defendants.
went out and said, I'm tired of billing. I'm going to offer misdemeanor.
Okay, let
And
me
you said no.
take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail.
Gotcha.
I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been handled.
Merchant, we can't even hear you.
Oh, I'm so sorry.
Just pull it
I didn't-
up right to
sorry.
you.
And tell the other guy
Pull
to
it the
stop
edge of
breathing
desk
into the
if you
mic.
have to, so everybody
Okay,
can hear.
sorry. Okay, so how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. they expanded it to include these 3 different classifications. What does that do? That means the trial is going to be a year. They can plea people out. They can plead Michael Roman out, they can plead this person out, they can plead people out, but they're always going to have that large enterprise. And it actually does,
pick a fight
even if
with
they pled
someone
my
who's
client
smarter
out,
than you.
the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation, because imagine if we just had, like you see in other cases, one defendant. You can limit the information to just that crime and that case, or you could have 3 separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have 3 trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case.
What did you learn?
In the case that you cited, physical or not,
Which one? Whitworth?
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking
This
to
guy
him, who's the
read one
prosecutor.
decision. He thinks he's master.
Hobbs informs Morgan, who is the prosecutor, that he anticipated the successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying this is the case you cite.
You cited
in
this case.
our case, in your case, they actually came to you and said, we're willing to give you.
Did you
a
not
plea."
hear her
And
answer?
you said no, which is perfectly fine.
Did you not just
But
hear
then
her
you
answer?
say, well, they want to extend prosecution on my client. They were willing to cut it off.
Did you not just listen
And
to
so
what she
therefore,
just said?
The case that you cite is totally opposite than the situation that you're dealing with.
Look at these guys
How
next
would
to
you
him like,
say
oh my
that
gosh.
you have a conflict in this case? Based on this case, just based on this case. That was your first case that you cited in your brief.
I don't think it was actually the first case, but
The first was actually a federal case, but the first Georgia case you cited was Whitworth
think
on
that's
this
right.
particular issue.
right on this
Sir,
particular
did you not
issue.
hear my
And
answer?
again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got is these financial disclosures where they're not being truthful. Ms. Willis is lying under oath.
Maybe he has COPD.
Which
I
is the
shouldn't
same
make
thing
fun
my
of him.
client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen unfortunately drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information
Lie
out.
under oath.
I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is and you have to
Who
cite
actually brings the case?
the district attorney. Well,
How do they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Waite. So he's the one that he presented most of the witnesses, presented.
How is your
most-
client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They
And
made
then-
a determination to bring charges, basically, to
yes.
indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this: it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it
By accident.
And the grand jury indicted.
So you're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No. No,
So the
and
grand
I know
jury-
that's- I know you guys have a bill doing that right now.
She is
No,
so
I definitely
smart.
don't think
It's
so. The grand jury is
unbelievable.
better than no oversight.
Correct.
Definitely, but it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is, I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear
Ex
from the
parte.
prosecutor. So, and they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. They actually, the prosecutor brings that indictment and then they vote and it's a majority. So all they have to do is a majority vote and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally. You've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So you went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3 already.
They were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents. He's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because
Excellent
he
point.
essentially couldn't work if he didn't enter a plea. And I mean, he got probation. You know, it was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine.
you got
The
Jen
other 2 people
Ellis.
who pled are both lawyers, lawyers at the end of their career, and
Now.
I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualifications. So,
yes.
but you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive
They
recommendations.
indict a ham sandwich, dude.
Stateside.
You know the
He's able to
expression.
go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
For a
That would
corrupt
be up for-
RICO.
up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral in
That's
that.
not surprising at all.
And he's going to a grand jury. And you say he's integral in that. Then why even say that he's unexperienced and he's getting people?
Because he's
to plead
never
guilty?
tried a felony, you
Basically,
moron.
You're saying those are just lawyers that don't want to do anything anymore, and they just pled their clients guilty. I
No,
understand.
no. So the special purpose grand jury, first of all,
Harold
my client
Jones
was
II.
not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the
yeah.
transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that along with Mr. Wooten, and he never did it all by himself. He definitely led it,
Harold
but Mr.
Jones.
Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified,
Pretty much.
it is important to realize that they've walked this case to this particular point. Very complicated case, I would
it's very
imagine.
complicated.
I mean, that's something that we could debate. If walking someone through the grand jury, the special purpose grand jury is complicated or not. Asking questions, and again, there's a team of 10 lawyers, so
So now it's a team of 10 lawyers.
who knows what part he's doing. But the question would be then, why him? Why not all of the public servants?
Yeah, a
who
team of
are
10
taking
lawyers. He
government
got
salaries
$650K.
and
Moron.
restricted in their private law practice. Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent, there's no adversary, there's no judge.
Once it became adversarial, you've had persons start
And
pleading. And maybe more potentially, correct? Possibly. But we'll find out.
Doesn't seem-
But let me ask you this, though, because you were
We'll
talking
find
about
out.
the
Threats.
staff. One of the reasons you may go outside of to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are.
No,
the
we're
office
not.
was-
No, we're not.
would basically shut down. It's a potential that the DA's office could actually basically shut down.
Oh God, no! If you took the $1 million that he's been paid, you could hire 5 lawyers.
Six
You
lawyers.
could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced ADAs are not going to make
He's going to-
$100,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term. If you're just saying the money you paid him, you could have done this, because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could have used this money for that, but that money was delegated for him.
It was never
as a
delegated.
short-term
It was never
project, so to
delegated to him.
speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney.
What the hell are you
to
talking
make
about?
that decision.
No, it wasn't up to her to
She's
make the
doing that. I just make the point.
Did this
that
guy listen to
so
anything?
far, from a district attorney's standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified.
I
I
just said a bunch of crap.
How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, "Hey, the contract because he works at her pleasure."
Oh, yeah.
So that
He
contract
works
can
at her
end
pleasure,
any
all right.
time. That
Yes.
would be the
Morons.
on the trips. How much total were the trips?
about $20,000.
Ooh, that's a lot.
And I think it was about 17,059. But even if we say 20,000,
Working at her pleasure.
cost of each one of those?
5,000.
Well,
4,000.
unfortunately, they did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but
I can't.
Going by your slide, one was 3,335, one was 4,453.
which one? Hold on, I want to make sure I'm clear.
Working at her pleasure.
6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, 3,000.
Vocal fry is very annoying.
453. And then we see the next one, and then the next two. How would that compare? I mean, what is that so unusual on price points as far as trips are concerned?
I mean, I don't think so.
He didn't say she overpaid.
Really well. I mean, Royal Caribbean. I specifically kept out the money that he spent on his mom's cabin. So they had 2 cabins. His mom had a cabin. They had an oceanfront balcony.
Cabin?
For the Bahamas.
Did you ever stay in a cabin?
From balconies, probably upper middle, but I don't know that it matters. Flew comfort class, not unnormal for a lawyer. I mean,
You know what maybe the average American spends on a vacation?
not this much.
You don't think?
No.
Have you looked?
Huh? No, I haven't, but I would imagine most of the Fulton County taxpayers
Idiot thinks
would love to go on any of those trips.
$20,000.
Well, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief,
I did
because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
Not
For a single
4 in a
person or
year.
a family?
Family of 4. Well, at that time, they were taking 2 and 3 at the time.
That makes
so
sense.
That makes
So
that's
these-
about
no.
normal.
Hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said 3,700 for a family of 4. That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
No, the average American
that's-
can afford to
Yes.
go.
This is half of that for 2 people. So you said 3,700 for a family of 4. This is for 2 people.
Right, it's just two people.
Right. So that,
Double it.
yes.
So it wouldn't necessarily be habit, it's two adults. Bottom line is it's not extravagant. It's not lavish, is it?
The law only says
Imagine these
$100.
arrogant pompous
It's not lavish.
And
Democrat.
that's one of the reasons I didn't
fuckers.
include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamans. I didn't include that. I didn't want to do the math. And I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year?
So your
my brief.
argument is that a person who makes $200,000 a year is actually setting up prosecutions to go on a trip that costs $3,500.
It was $20,000 worth.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in
Speculating is the
briefs
word of
that
the day,
says
people.
This is the benefit that she got, and all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400.
These guys can't believe.
And they have made up all these
These
prosecutions.
guys
to
are
go on
like,
a 3-day
can't
cruise
believe what they're listening
for
to.
$3,300. I mean, that's your argument. That's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So, we did
What
argue
else is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the
Lying
brief?
under oath,
A
perjury.
lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are on
That's what's in the
trips.
brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof. And so that's the proof that we
shut
have.
up. That's
that-
why that's what I
That
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh, yeah. And so,
Understand.
what I included was what I had the actual hard proof of. And then
shut
some of
his
it's attached to the
mouth
brief.
already.
Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted.
They were
And
taking
there were a lot of other
trips a
receipts
year.
that I had that I did not know for sure if they were joined. And so I didn't include those. And I haven't talked
You
about them
shouldn't,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes,
They
you're
took
dealing
2
with
trips
hard
a year.
proof.
The average
Correct.
American.
That. So my next question then becomes,
Then becomes. How do
on
I?
the conflict as far as his salary is concerned, just curious. Is it the amount of salary that you really creates the conflict? I mean,
They tried to argue
because
this already
we get
in
stuck on
court.
money a lot. So is the amount of salary that is creating this conflict in your mind?
No,
In other-
it's
or is
the
just the
fact that
fact that he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Miss Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on and they were hiding it from the
Stuff,
taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
Oh, I do because of the Fulton County laws. The laws say that they
I'm
can.
talking. I don't understand the county codes, but I'm talking about as far as like
I don't want to talk about that.
what the case law says, which is
Oh, yeah.
what the judge is actually going to. If there's no,
What judge argue in court? You're doing worse than Abate.
if you're not hiding that or against the Fulton County ordinances,
They were
do you
hiding it,
believe-
though.
Do you believe that there's a conflict? If they brought it out and said, "Hey, we're dating," is it a conflict in your mind?
They only brought it out once I alleged it and they called me a liar multiple times.
What I'm saying is that they brought it out. Would it be a conflict in your mind?
If
Is it a
they-
conflict?
Here in a
And what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J,
Clip this.
knowing that, Exhibit J, we wouldn't be here.
Clip it. Shut up there. You got any more
So then your
questions?
client
Sonny?
actually has no conflict because that would still exist. Your client has no hard conflict then.
Oh, he's got a
no
hard con-
actual conflict. It doesn't matter.
Your
if you
client's
disclose-
got the conflict.
If you disclose the conflict, it still exists. If you
If disclose it, it's not a conflict, you
one of the
moron.
cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict.
The
So what you're
harm is
describing
in
is
not
a
disclosing
conflict
it.
at all. You're just saying, I caught somebody,
Oh my
so therefore
God.
I'm going to create something and call it a conflict. You cannot waive a conflict like that. You
No,
just could.
so-
If your client is, you could not do that
Can you
for your
can you
own
be
client.
quiet now?
If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand your question to me.
Look at the guy behind
You
him.
don't have a conflict if you're saying if she disclosed it, it would go away. Then there is no
No,
conflict.
no, no. I did not say that. I said we would not be here if that had happened.
Right,
That's what
because
I
you
said.
wouldn't claim there's a conflict.
No, because
They would have disclosed
we
it.
wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
This guy's worse than the bartender.
If she disclosed it, not the way you said it.
If,
But if it was
the
disclosed,
facts- hold
it's
on.
disclosed
If
now,
she
what is the
disclosed
conflict?
The undisputed facts, the facts that we all, your side and my side.
How is your
understand.
client harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention
Of the laws.
So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what
And what,
could have happened.
what case law do you point to prove that?
Oh, the statutes. It's
No, it's not a stat, not Fulton County statute. I'm asking the Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says
This
that?
guy sounds
It's
like
not.
Ian
and
Copeland.
it's really not surprising, honestly, because can you imagine this happening? I mean, honestly,
happens.
in December, would you have imagined this happening? I think most people would.
I
All sorts
don't
of
want the
conflicts that
statutes.
Are taken up by the Court of Appeals.
I
I
can
don't want
tell
the
you, I have
statutes.
found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours? Because
Oh, he's billing hours.
I mean, I don't.
He's
I wasn't
billing
there.
hours because
Oh,
he's
he's
prosecuting.
billing
the case,
hours.
right?
I
A case that a
would
grand
hope.
jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I
wanna
mean, words
speculate.
do matter when we say that she's not paying him in that sense. He's earning money for a case that he is in charge of prosecuting, that a grand jury indicted, and that's where we are.
You're
That's-
correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Employees, yes.
100%. And that he is part of that process, and he is prosecuting a case that you're involved in. Correct? He is he's prosecuting, and he's been integral in that prosecution.
Does this guy not
And you said
understand
that.
how stupid
I
he
mean,
sounds?
he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir.
Are you getting
I
close to
just have one
anything
last question, and that was
of
in
a
the case
rational
that you
thought?
cited, it clearly says
Which case? I'm sorry.
in
Witten?
Whitworth versus State, it clearly says the prosecutor should see no unfair advantage in taking advantage of the accused.
Grandstanding is all he
Creates
can
the
do.
Conflict. What unfair advantage has he done in this case?
You've asked me a
$700,000.
lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people. I'm visual. I like to see it. Come
You
on.
guys are down to it.
Thank you.
Oh my goodness. What's the actual conflict? The $700,000 he got
She's
paid.
looking at this.
But he did
We're
work.
gonna wrap
Oh.
up here in a few minutes.
Yep.
I wanted to let the public know how you can get information to us.
Ooh,
Each
calls to the
senator
public.
on the committee has a separate email address for committee business. And it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for investigation committee. So each senator, their last name,
I'm just gonna
.inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv.
Look at the way the guy there, Harold is
Senate.ga.gov.
sitting down.
I've had a number of citizens that have reached out and wanted to provide information or be heard,
Including the waiter?
or testify possibly in front of this committee.
Oh, yeah, bring it.
We are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for
Good.
additional questioning after today, but I'm not rushing. Take your time, read that.
Can it not be the first week of April?
Yeah,
Cobb County spring break, please.
that'd be fine.
Thank you.
So I'm going to cough again.
Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case,
She's gonna destroy him.
J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk, wait.
Oh, I'm sorry, I forgot the microphone.
Look at the way this jackass is sitting there with.
He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish.
Guy's not
that.
listening to a damn
That's the
word she's
big
saying.
issue. And the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens. And that's what you have there.
In this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but
No,
they
you don't.
never discussed that because no conflict existed. And you're right, it is post-conviction, but bottom line is you really did not address the aspects that I was talking about
okay.
when there is a conflict. And it's not me putting this case in, talking about a conflict.
you.
It's a case that you guys actually did cite. With that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So
Bam!
we cite adverse authority all the time.
Adverse authority, but that's fine.
He has to get the last word.
Oral arguments that we did, that was how the oral arguments started. So.